The other important thing to note is this other beast called a maritime performing party. So we've met the performing party. Now there's a further subdivision, a maritime performing party. And a maritime performing party is anyone who does anything with the goods within port limits. So it is anyone connected with a port or the actual sea leg, not inland. The only difference with maritime performing parties is they are liable for their period of performance only. So if you look at this example, let's assume the carrier, the contracting carrier, picks up the goods right at the left-hand side, over there. That is when its period of liability starts. And no matter where the goods are damaged, whether it's here, there, or there, the carrier will still be liable. Let's assume that at the port it hands it on to carrier number 1, who looks after it, hands it over to the second carrier, hands it over to a third carrier or handler of the cargo. Those are all maritime performing parties if they are within port limits. They are also responsible, just as the carrier is responsible, but only as far as they handled the goods. So let's assume maritime performing party number 1, the green party, is a stevedore. If they drop the goods, the shipper has a choice. The shipper can sue the carrier, and the carrier can't raise any defences because it's liable for performing parties. Or the shipper can sue the maritime performing party directly, whichever is more convenient. The maritime performing party can't say, well, it's the carrier's fault, because it is liable for goods that are damaged while on its watch. So it makes it much easier for the shipper to get compensation. As between these two, the carrier and the maritime performing party, they have to sort it out between themselves. It's got nothing to do with the shipper. So you can see it's a different concept. It is proper joint and several liability, and the shipper is given a direct right of action, which it would not necessarily have under the Hague and Hague-Visby rules. Okay, the other thing that the Rotterdam Rules do is it extends to other parties beyond the carrier. I pointed out to you right at the outset that all of the other regimes are carrier liability regimes. Rotterdam has another philosophy. One of the major changes that was decided on early on is that it would cover both the responsibilities of the carrier and the shipper. And so they've introduced new parties. It still refers to shipper and consignee in the sense that we know them already, but there are these two new concepts. The first is the so-called documentary shipper. And that is simply a person who is named as the shipper in the transport documents, but who is not the actual shipper. In other words, it's not their goods, and they have no direct interest in the goods, but they appear in the bill of lading or other transport document. So for the first time, freight forwarders are covered directly by the convention. It goes broader than simply looking at the relationship between shipper and carrier and consignee. It now starts saying, well, what about freight forwarders? So whenever a freight forwarder puts its name on a bill of lading, it is now called a documentary shipper under the Rotterdam Rules. And that imposes some duties that we'll look at in a second. And that's one of the reasons why freight forwarders are a wee bit concerned about the Rotterdam Rules. The other beast we've not come across before is the so-called controlling party. And the controlling party is the person who has the right to dispose of the goods. So they're the person who has the right to instruct the carrier what to do with the goods. Now in most cases, that's going to either be the shipper or the consignee, depending on who's holding the transport documents. So you might ask yourself, well, why do we really need this new concept? It's either the seller or the buyer, the shipper or the consignee, that has the right to retain control of goods. But this controlling party idea seems to have been dreamt up to cover third parties like financing banks. So you will know that a lot of international trade is financed under documentary credits, in terms of which a bank will forward payment as against documents. Usually the bank has no interest in the goods at all. It simply wishes to sell the documents on, as it were. But sometimes something goes wrong and the bank is left with the documents. What the Rotterdam Rules then does is it would define them as a controlling party. So if the bank is not paid, it can then use the transport documents and say to the carrier, I am the controlling party. This is what you do with the goods. Now, I think you can pretty much get that result under common law already, but the Rotterdam Rules clarifies and defines it. Okay, so carry on this theme of extending to other parties. As I said, the idea is now the liability of the shipper as well as the carrier is covered in Chapter 7. And the Rotterdam Rules spell out far more clearly what the duties of a shipper are. In both Hague and Hague-Visby rules, there's very little about what the shipper has to do, just a mention in passing. Chapter 7 now provides detailed instructions on what the shipper has to give the carrier in order to facilitate trade. The most important aspect of Chapter 7 is probably the special rules on dangerous goods. So there are quite detailed instructions on what a shipper has to do to provide information on dangerous goods. Failure to do so renders the shipper liable to pay compensation to the carrier if any damage is caused. But now here's where it gets interesting. Chapter 7 says a documentary shipper is also liable for misinformation. So it's not just the actual shipper. Any person named in the transport documents is responsible for the information in them. So if a freight forwarder is named in the documents and no declaration is made as to dangerous goods, and it later turns out there were dangerous goods and harm is caused, the freight forwarder will be directly liable, even though they're relying on information given to them by the shipper. Of course they can recover from the shipper, but if the shipper's bankrupt, that's going to be fairly cold comfort. So this is one of the major reasons why the freight forwarders are concerned about the Rotterdam Rules and are not very happy about this requirement to provide information and liability if they don't. It may be that in practical terms we'll be able to get around this through indemnities. It may be a good thing in the sense that freight forwarders will check far more carefully. But it's also been argued to be far too bureaucratic and far too difficult a burden to place on freight forwarders. The other controversial aspect to Chapter 7 is that the shippers and the documentary shipper's liability to the carrier is unlimited. There's no limitation of liability that applies to shippers. And most commentators have said, well, hang on a minute, if carriers get to limit their liability, why not shippers? So I think, I personally agree with that, and I think they missed a trick with Chapter 7. I think that it would have been good to apply the same limits of liability to shippers as it were to carriers. Now, the reasoning seems to be that shippers are far less likely to cause damage to carriers, but if you just think of the example of dangerous goods, if there are undisclosed dangerous goods in cargo, that can cause an awful mess, and it then means that the shippers are liable for the entire liability, or their underwriters are at any rate. Okay, a further important development is that the Rotterdam Rules fully cover EDI, electronic data interchange, and other forms of transport documents. We know Hague and Hague-Visby designed before electronic bills of lading were ever thought of. Rotterdam really doesn't do it very well. Hamburg rules really don't deal with electronic bills of lading very well. Rotterdam now does. And Chapter 3 expressly allows for it. It treats them in exactly the same way as it does paper documentation. And it says that electronic records can be used provided the shipper and the carrier agree. So I think this is a major innovation and a good step forward, because we're going to increasingly see use of electronic transport documents.